This is Paul. Yeah. If you're serving the other party out of state, you must complete and file this form. Yeah. Before the judge will sign the final order. Yep. The party personally served out of state has 60 days to respond. Yes. If the papers are personally handed to him or her. Yes. Declaration regarding personal service outside of the state of Washington. Yeah. See, yesterday I thought, what if I wanted to modify the dissolution of marriage? Yes. I wanted to modify the protection order. Right. And I did move to a different state, and I had to serve the petitioner, and she would have 60 days to respond to any of my modification requests. If the paper served included a protection or restraining order, example, you must also deliver a copy of the return of service to law enforcement agency. This agency is named in the order. Yeah. Now, just going through to both parties. Yeah. See, I mentioned the show cause hearing. Yes. Where you did that, but I didn't get service. No. I didn't get any notice of it. Yes. But it says here, deadline, your papers must be filed and served by the deadline in your county's local court rules, yes, or by the state court rules. If there's no local rules, yeah. If you want the court to consider your side, you must file your original documents with the Superior Court clerk, yeah, and give the judge commissioner a copy of your papers, the required county's local court rules, and have a copy of your papers served on the other party or their lawyers, and go to the hearing. It is a requirement to have you appear at the hearing for a show cause hearing. But the last time you issued a protection order, I don't think the petitioner appeared in court. Yes. And you said, well, it doesn't really matter as long as the judge signs it. It doesn't really matter because the petitioner, yes, is not obligated to appear in court. Well, any of these other court hearings where the petitioner wasn't obligated to appear in court? The proof of mailing, undeliverable mail, yes, order for protection, a renewal of protection order, reissuing temporary protection order, show cause. Yes. Now, this is for a family court show cause hearing. Yeah. Did the petitioner appear at that court hearing? Well, seems like you made some sort of exception to the actual rule that you have to go to the hearing. Yes. And in your discretion, after 15 court hearings, yeah, you decided that you don't have to enforce any of the civil laws of the state of Washington. You know, Brent, you're having a difficult time right now. It says go to the hearing. To the person requesting, you must have this order in the paperwork you filed with the court to get this order personally served on the other party. Yes, by someone 18 or older who is not a party to this case. Yeah. Now, what other court hearings didn't the petitioner appear at? Yes. Out of all of them. Yes. From July 8th of 2011 until July 31st of 2015, of all the court hearings that you had, which of them did she not appear at? Yes. Because the way that I'm looking at it, yes, there's some sort of state law. Yes. It's known as an RCW. That if you appear at this court hearing, yeah, and if you appear two, three, four, yes, four, yeah, five, yes, six, yeah, seven, eight, yeah, nine, 10, yeah, and then 11, and then show cause hearing 11, yes, let's see, 12, and then 13, yes, and 14. The RCW say that if you don't appear in court after your 15th court hearing for orders for protection or modification